So for today, all we're gonna do is run through the cases and the hearsay statute, and then I'll assign the roles for next Tuesday. And then next Tuesday, we'll do the role-playing exercise, and you'll have to have read all of the cases by then. Okay. Somebody just reminded me in the last 10 minutes of class or so to come back to the assignment.
And when you say the role playing, what particular case are we going to do?
The assignment, the child sexual abuse assignment, class assignment that I handed out last class. So have that handy for the latter half of today's class. We'll talk about it. So the first case is Colin, but if whoever wants to begin Colin, also put it in context of Chapter 233, Section 81, the hearsay statute. Who wants to start to talk about Colin?
You want me to do it? This is the one with, I don't have the first page of that, so I'm assuming that's the one with the boy that was charged of rape. Is that the case?
Yeah.
What is something that has the first?
The first page, yeah, that's the first one,
Right,
right?
Lily's gonna do it. Go ahead.
There was a teenage boy that was, he was charged with raping younger boys, and, one of the boys, he told his mom about what was going on in the treehouse, and one of the
The
boys.
victim. What-
Yeah, the victim.
Okay.
He knew the difference between, telling a lie and telling the truth. So, and he could understand the consequences of telling a lie, so his, disclosures were admissible. And, they were saying that the defendant is supposed to be given an opportunity to respond to any type of hearsay allegations. And, the Commonwealth needs to give the defendant notice, if they're seeking to use, hearsay statements by witnesses or victims.
Okay.
And they need to show, or the state needs to show, that they need to use it by more than just the preponderance of evidence. And that's all I really got from that case.
So all these things that you're saying, Lily, that in relative to the SJC's decision of the Commonwealth v. Colin case, what is the SJC doing? Now remember at around the same time, the statute 233-81 was enacted, right?
And
So is that what the SJC, besides deciding specifically the Colin case that dealt with the sexual assault of some young kids, is the SJC also doing something else, getting out and
They
saying,
ruled,
yeah?
yeah, they said that the statute was, not unconstitutional.
The 233-81
Yeah.
passed constitutional
Article
muster.
12, it says we however rule that the statute is facially unconstitutional. We do not, however. So they're saying that it's okay.
So it's okay, but what safeguards does the statute contain that the SJC made comment about and is cautioning later courts and later judges to make sure that they follow these procedures?
I got out of it, it had a lot to do with the expert witness.
Hold up about the expert and say that is a side ruling as well.
they needed like a separate hearing, right, to corroborate what,
Why do you need corroboration?
to.
So what are we talking about here? We're talking about out-of-court statements, right?
Yeah.
Of children under 10, who have been sexually abused, sexually molested. So in what context, in terms of a criminal case, can those statements come in?
When it's necessary and when the statement is reliable.
What does that mean, the reliability?
It means that it has to be proved, not beyond a reasonable doubt, but with a fair preponderance of evidence, that the statement is reliable.
So the judge has to hold a specific, and you said it before, separate hearing when the issue comes up. Gee, there's gonna be, we're gonna be putting in evidence, some out-of-court statements. So there has to be a special hearing in order to determine if the statement's gonna be admissible based on reliability, and what's the other factor?
They also didn't want just that child's here, I think there had to be other evidence besides just that statement.
What does that mean?
So
There's
that-
one word for that.
Necessity?
Not necessity.
Indi-
Corroboration. Remember Ned's mother had notes of the statements, and the premise was that the statements were consistent with those that he made to the doctor. So Ned's statements were made in circumstances inherently, and this is a quote from the opinion, inherently demonstrating a special guarantee of reliability. Why do you need all those safeguards in a criminal case and under 233-81? I mean, shouldn't it be enough? This is an abuse of a child. The statute is allowing hearsay statements, but it looks like the state has to jump through a lot of hoops, right? Separate hearing, Lily also mentioned prior notice to the defendant, must show more than a preponderance, a compelling need, separate hearing on reliability, you gotta show corroboration. Why all those hoops? I mean,
Because the Article 12 provides that every criminal defendant shall have a right to meet the witness against him face to face.
right, so we're talking about defendant's liberty rights, defendant who, as a result of this procedure, is really in danger of losing liberty rights. It's a criminal case, therefore the standard is very high, even though, this is a statute that is an exception to the hearsay rule. What is the hearsay rule?
We did the cake.
Any out-of-court statement offered,
Go ahead, say it again slow. No.
any out-of-court statement made to,
What?
Go ahead, Danielle.
Kegel had us like, no.
Any out-of-court statement offered to prove the truth of the matter asserted there.
The online people can't hear you, Danielle.
He skipped the middle part.
All right, you say it now.
Oh,
You
no,
have
What's
to give
your
your
definition? Any out-of-court statement.
Statement offered in
To
evidence.
prove the truth of the matter asserted therein, except the party's own statement.
Well, you don't forget the except, because then
Okay.
there's
So I didn't-
1,001
It's
exceptions,
any
right?
statement,
Out-of-court statement.
any statement offered.
Offered in evidence.
Offered in evidence,
To prove the truth
other
of the matter.
than,
Forget the other than.
it's the,
Because once you get to the other parts, then you have to mention a
Every
ton
state
of
code.
exceptions.
Yeah.
Think of the rules
Hearsay is a statement, other than one offered into evidence, while testifying at trial or hearing
Okay, too many words
by
here
the
now.
declarant, well, this is how Hegel taught us.
All right, coins is any out-of-court statement offered
And
to
that's it.
prove the truth of the matter
He
asserted
just had a
therein.
different one.
Okay, mine is close. Any out-of-court statement offered in evidence, it's gonna be offered during trial to prove the truth of the matter asserted. And then there are a million exceptions. This happens to be a statutory exception. You don't always get that. This was, in fact, the sexual abuse assignment role-playing thing that you guys are gonna do, when I was involved in that case, the statute had not been created yet. Keep that in mind, because we're sort of gonna, we might do role-playing with the statute at times and without, but, we'll talk about how we're gonna do that later on. So that was fairly sort of revolutionary, when the statute was promulgated back in, I forget, early 90s or something like that. So that's Commonwealth v. Collin. It's the leading case that construed, shortly after the statute was promulgated, that the statute was constitutional, but that courts had to be careful that they followed these procedures. Oh yeah, and Danielle, you mentioned the expert, and I said I come back to that. What was the court's ruling about the expert in the Collin case?
The expert had basically said that it was in his opinion that the children had been sexually molested.
Yeah, what's wrong with that?
The jury should have been allowed to make that decision and been able to take.
And why?
Well, because
That's up for the jury to find your fact.
Right.
their knowledge and
Absolutely.
it says their knowledge and may aid them in reaching the decision. So the expert testimony is to help the jury put all the pieces together.
Exactly.
But he should have put them together for them.
Exactly. The expert is going to can't offer opinion, but on something that exactly what Norman said, that the fact finder is equally competent to assess, as the court said. So the expert testimony could be about behavioral characteristics of sexual assault, sexual abuse victims. Can't testify, oh gee, Johnny was sexually assaulted. It's my opinion. Well, I mean, that's the ultimate issue in the case. So that was the other ruling from Collin, which there are tons of other cases, civil, criminal, et cetera, that make that same proposition that experts really can't testify about the ultimate issue. To me, what's more important about Collin is that it was that first ruling shortly after the statute was promulgated that, allowed the Superior Court and juvenile court judges afterwards had, besides the statute, they now had an SJC case to follow in what they should be doing when they have a 233-81 issue in a sexual assault case. Okay, but these cases aren't really in any order. And the next one is the Eleanor case, which is much earlier, 1993. And somebody tell me about Eleanor, custody of Eleanor. Alana. I'll get it right.
I know, it's very confusing. This is the case where the girl, she was 7 years old, she was actually brought in for an infection, and the mother...
She was brought what? I'm sorry?
In for an infection to the hospital.
Oh, okay.
And the mother informed the doctor that Eleanor had told her that the boyfriend had actually touched her. She later recanted that statement, but a bunch of other reports were filed alleging that the mother continued to emotionally neglect Eleanor and her younger sister. Basically, by way of procedure, the trial court or juvenile court, they ordered temporary custody of Eleanor and the younger sister to the department, and they ordered that they be placed in foster care, and ordered the mother's boyfriend to have no physical or no contact at all with the daughters. The appeals court later reversed, and the Supreme Judicial Court agreed with the appeals court reversal, but for different reasons. Basically, the Supreme Court stated that the underpinning that Flanders sexually abused Eleanor was the whole basis for the finding that the parental was unfit, and that was based on the one incident of sexual abuse that was later recanted, and that it cannot be said that parental unfitness was proved by clear and convincing evidence in this case based on that one incident.
Okay, good. There are a number of things going on here that you might think about and apply to later cases dealing with, not only child sexual abuse, but abuse and neglect and non-offending spouses and so forth. First question I want to ask about is the standard of review in child custody cases. What is the standard of review that the court says should apply? Not for the trial itself, but the standard of review. So when the SJC or the appeals court is reviewing a custody case that came to them, what standard does the court apply? So that's different from standard of proof. You just mentioned clear and convincing evidence, which is standard of proof is trial. You guys the difference, right? Standard of proof for example, in a criminal trial is, beyond a reasonable doubt. The standard of review, whenever you hear the word review, it generally denotes, either an appellate court or some tribunal that's reviewing something that somebody below has done, right? So in order for the appeals court of the SJC to overturn something that a lower court did, in this case, a juvenile court, right? Or a probate court, I'm sorry. What is the standard by which the appellate court would overturn or reverse?
Is this when you're talking about the specific and detailed findings?
Keep talking about the findings of the trial judge.
Okay, so they have to be specific and detailed, and.
And if the appellate court, Alana, is gonna overturn,
Right.
it has to be convinced that the trial court did what?
That it was an error, that the error.
Yeah, clearly erroneous, right? Do you see that language in the, all right, so keep that in mind. The trial judge has to be, the judge's findings have to be clearly erroneous. So while in Eleanor, none of the findings were clearly erroneous, but now, the other piece of it, you mentioned clear and convincing evidence, but the evidence on which the findings were based did not prove parental unfitness by clear and convincing evidence. So see the difference? So even though the findings themselves were not clearly erroneous, the court now looking at the whole case said, you know what? The judge below could not have found parental unfitness by clear and convincing evidence based on those findings. Why not? So you have a child that said dad or someone in dad's position had been inappropriate with her sexually. You have the child that recanted. By the way, what's the lowdown on children recanting?
Well, a lot of them recanted so they can go and be back with their parents. I mean, I think it's a pretty high rate of children ended up saying something else after they've admitted something. I think they come back because they don't want to discuss it, and or because they feel like they've now been separated from their family, and the way to get back is to undo the lie, that everyone's saying it is.
Okay. What else? What did the judge do relative to the profile evidence of, the name was Flanders, I think? Yeah.
You mean about his history?
Yeah, did the judge in that case rely on profile evidence that Flanders may have demonstrated, characteristics generally associated with sexual offenders?
He had he actually, didn't he have a sexual offender evaluation was conducted? And it found that he had characteristics in his history and psychological test findings associated with child sexual offenders. And that doctor, I think, recommended.
So that in and of itself was okay. Everybody with me on that? That the judge could hear something like that.
What?
So in the end, what's really wrong? What really causes reversal? We go back to that clear and convincing standard, which is a really high standard. Because in the end, what did the department really have for evidence? Had the one statement. The one statement's recanted. There's some profile evidence, but there's nothing much else. And remember, I said to you guys on Tuesday that the sad thing about many of these cases is that only the abuser and the victim really know what's going on. And sometimes either the department, if it's the civil case, or the district attorney's office really has not much else. And that was the main reason for 233, 81, 82, and 83 to be promulgated, to allow, an exception to the general hearsay rule that, we don't always have the evidence because, the kid says it first, could be traumatized, if he or she has to say it again, then they end up recanting. Sometimes we don't have, physical evidence of it if the child hasn't been raped or penetrated or whatnot. So if we don't have all this stuff, why can't we rely on the out-of-court statement of the child that does tend to be reliable, if it can be corroborated in some sense? So again, an early sort of case before the statute, didn't talk about the statute, but I think it's important in terms of remembering that burden at trial of clear and convincing evidence is a really high burden for the department, and rightfully so, because it goes back to the parental rights that you guys studied in the first 4 weeks. Now let's do adoption of Carlos. You want to do Carlos?
There are a couple more things on recanting, is that the
Okay,
child,
go ahead.
the child doesn't, the child doesn't want to break up the family.
Yeah.
And also,
yeah.
you know, the child doesn't want to see the parent or the parent figure get in trouble. Those are, you know, like, I mean, it seems like a lot of the cases deal with that issue. And the recanting thing comes up more than once.
Yes, absolutely. You want to do Carlos?
You know what I'd really like to do? I'd like to do that, the one where the guy was born in 1928. It's, I think this.
Okay,
I wanted-
I'll call on you in a few minutes.
All right.
All right, Marina's going to do Carlos.
I read it.
I don't know what he's talking about, but.
No, it's a later case, and it starts like the last three cases. That you say they may be in no order, but it seems like the last
Did
three
these get
cases,
worse next week?
What?
they just got so horrific. You know, like 7, 8, 9 were like,
Yeah,
you know, like,
I know.
So you like horrors?
I was afraid I'd have nightmares.
Yeah, I know. That's why I like them.
Marina, you can start anytime.
Okay. Carlos was born in 1982. He was born outside of a wedlock, and his father died. He basically didn't show any interest when he was alive in upbringing.
It didn't show any what?
Interest in upbringing Carlos. He was not in the picture. So Carlos' mother remarried,
Okay.
and he had a stepfather, and he referred to him as a real father. He didn't know anybody else, just as a father figure.
Okay.
When he was 3 years old, I believe he had a half brother. And then in 1986, when his mother was hospitalized, Carlos stayed with his father, and then he relayed to his maternal grandparents that he was sexually abused by his stepfather.
Yep.
And the maternal grandparents brought this to the mother's attention. So the judge found, he basically heard all the testimony, I believe, and he understood that, yes, it did happen. There was a clear and convincing evidence that this did happen at least once. And the mother of Carlos, she didn't want to agree with that, and the judge made extensive findings with respect to the mother's and stepfather's characteristics, and he found out that the mother was absolutely dependent on her husband, and she was really passive in his presence, and he was her source of support and security. So she didn't want to believe, and she totally denied that her son Carlos was abused. As a result, the mother was, I believe, deprived of her. She was found unfit as a parent for Carlos, and she appeals. And there is like a long discussion. We can talk about this.
Can you come back to that for a moment?
The mother was.
What about the petition to dispense with parental consent to adoption? Consider.
Yeah, but that's because she was found unfit because she failed to protect her child from sexual abusive co-parent. And later on in the case, she realized that Carlos was abused,
Okay.
but she
Or
just
began to make some progress as the Go ahead. Yeah.
this direction. But she also expressed that she would be able to protect me in any way. And unfortunately for her, the appellate court also affirmed this decision, and she
I'm
didn't get
sorry,
the rights.
affirmed what decision?
The decision that she was unfit and that the kid was, I believe it was given for adoption.
Are you sure?
I'm kind of confused with so many cases here.
The history was perfect, Marina. It's your conclusions. Somebody help her out. Ashley?
They said that you can look at the future
Wait,
unfitness of the
what did the trial judge find relative to, notice it's adoption of Carlos, so that was not just a care and protection case. That was a petition to dispense with parental consent to adoption. So what did the trial judge
They denied
rule on?
the petition.
I'm sorry?
They denied the
They denied
petition.
Yeah, and the SJC affirms that.
Right.
So in that respect, mother, wins because she doesn't lose parental rights.
Right.
Okay,
Okay,
everybody
so
with
that's
me
what
on that?
confused, yeah.
So go ahead. What else were you gonna say, Ashley? Because I
Oh, just that they said that you couldn't look at the future fitness of a parent when you're about to terminate their rights. You have to look at their fitness as of that moment.
Are you sure?
So,
Everybody's looking
I
again.
think it was the other way around, wasn't it? Like, you should take into consideration the future fitness of the parent, because you want to try to best kind of
When you're terminating parental rights, consideration of future parental fitness can be appropriate. I mean, it might not be the end-all and be-all, but it could be something the court takes into consideration. Remember how drastic that termination of parental rights is? And all along, Mom, and Marina said it perfectly, was even though she was the non-offending spouse, she was, in essence, really not protecting the child by, allowing in some ways the abuse to happen. And that, now remember, along the way, the department has all these service plans. And the department would have been testifying at trial and so forth, had experts that showed that Mom is not recognizing, for one reason or another. Because remember I said at last class that also DV, domestic violence and child sexual abuse, are interrelated. So she may have been suffering herself as a result and not been able to recognize or help or protect. But that still means that she's unable and unsuitable at that period of time to take care of her child. But by the time the case went to trial, the court said, you know what, I don't want to go all the way to, I'm not going to terminate parental rights here. She's made some progress. In fact, I think the word was significant progress from when the case.
Not very far.
Okay.
This case, I mean, I have exclamation points all over this case.
Yeah,
Irritated me. If
yeah.
I was a DSS worker or an attorney at the
And
time.
I'm sure they were irritated because they were trying to
It's
terminate
ridiculous.
parental rights.
It's been 6 years. It's been
Mhm.
6 years. And I even wrote, who are we worried about here?
Mhm.
And the fact that they, the department's not willing to weigh the considerations of the parents facing criminal charges just really got me aggravated that it's supposed to be about the child. And it seems like in these parent cases.
But let me stop you for a second because here's a, I think I'm reading from a quote because I have something else here, but I can't tell. Wait a minute. Parental fitness and the best interest of the child are interrelated factors. The judgment must analyze the parent's character, temperament, capacity, and conduct in relation to the particular child's needs, age, affections, and environment. So, I know what you're saying. From when a care and protection case starts, the focus is a parent unsuitable and ultimately unfit to care for his or her child. The courts have said that the fitness factor and the best interest are not, and I'm quoting from, I think, The Little Wanderers, is that what you're going to do, Norman? Are not separate and distinct, but cognate and connected. So it's hard to sort of because you're thinking about the whole family. And remember, the department's goal from day one is to do what it can, do, strengthen and encourage family life, to, seek out what the problems and what the issues are and see if it can help. I mean, in this case, the department probably, as I mentioned before, probably had the service plan from day one. Get him out, get him out,
Why
get
was
help.
the father's
like-
potential, why is it that this judge or the court is looking at, and I really wanna know, so, under parental fitness, the father's perception of going to jail is connected to the parental fitness? And that they're saying, well, he's just scared he might go to jail, so let's look beyond that and do something else for service to his family. I think that's pretty, I don't see how they fit that in, that they seem to be putting this on the department to not understand.
Yes, it is.
Yeah, to not understand that parental fitness might be that the stepfather's afraid to go to, I mean, it says, the risk,
Wait a minute, that the mother, concentrate on the mother, because it's the mother's parental rights we're talking about. That the mother's
that she's-
afraid
right.
that her husband or her boyfriend will be going to jail. Is that what you're saying?
Well, they say in this paragraph that kind of aggravated me, that she was more worried about the termination of her marriage.
Yeah.
And they seem to use, the court seemed to use that as something significant, that it's okay, she's not doing this because, well, here's the reason, so it's okay. Let's let her continue her parental rights because she's only afraid she's gonna lose her marriage. But this child is in foster care for
Yes,
6 years.
it's sad, very, very, yeah.
So that
Yeah,
parental
yeah.
fitness isn't
Yeah.
just, are they feeding the child, are they clothing the child? It also gets into so even if they're mentally unstable or selfish, that isn't as big of a factor in parental fitness
Right.
as like food, clothing, shelter? Is that what that means?
Very unclear, isn't it?
Well, I don't know what parental
Yeah.
fitness is.
Yeah, and I don't know, after so many years, what parental, if you asked me to write about it, yeah, I'd be all over the spectrum, and it depends on a lot of things. Depends on the case, depends on the parents.
I think
I think all the court is saying here doesn't mean that, and who knows what, if you went back in time to, after this case went back down, the care and protection piece of it would still be open. This didn't mean that mother, got the kid back, you're right. So the care and protection case would have still been open, she still would have had to follow service plans and whatnot. And then the case might have proceeded again to adoption termination. It's just that the court is saying that, the trial judge was right, because there really wasn't, by the time the adoption case went to trial, you have to show current parental fitness in terms of the best interest of the child, and where she was at that time, starting to recognize. Think in terms of also the abused, the abused victim, the victim of abuse, which she could have been, that it takes them time to realize and so forth. And that term, that quote, significant progress, really tells a lot.
I didn't get that from, I got that they felt the mother's position has evolved, although not very far.
Yeah.
I didn't think that was significant.
Oh, okay. The significant progress somewhere else, because I've got the quote, significant process, progress as well.
Oh.
But
I didn't get that it was very much, but I think the judge was, or they were trying to.
Yes, just
give
for
her
the trial judge.
The FCC, I think they were trying to give the mother the benefit of the doubt that even though it wasn't much, maybe it was when it
Because,
backed
yeah,
out. 'Cause
termination is so drastic.
She did
So
move.
drastic, even if you've been really bad to your kids, you still have some rights. Go ahead, I'm sorry.
Well, I guess, it makes you wonder, like, how far does a parent have to go in terms of allowing this, the abuse to take place? I mean, I got the impression that the court was like really trying to give the mother every benefit of the doubt.
Right,
To
right.
not have to do the Section 3,
And,
Right. Yeah.
So, and I think he was like really looking real hard to see that, you know, she maybe had moved an inch.
Yeah, if I may, what bothered me in this case is that it was written like somebody was fortune teller more than just based on the facts of the case. Because it says here, the natural bond between parent and child should not be permanently severed unless the child's present or future welfare
demands it. Yep.
But it's hard kind of to make that decision based on the future. Nobody knows what would happen in the future. And here the court kind of made that prediction saying, oh yeah, she made this, even though she improved not in significantly, we think that she's going to be better, and based on that we think that's going to be better in the future, we're not going to sever their bond.
And also, again, keep in mind, and what I just said before, and the court stresses it too, that there's a major difference between the care and protection proceeding, where the parent just loses, you know, custody, and it's reviewable between that case, and that could be based on, you know, the parent's current unfitness, so she could be currently unfit. Even if she's made progress, she could be currently unfit, lose custody, but courts are sometimes reluctant to take that drastic step of terminating parental rights. So, you know, major difference between the two, and where she made some baby steps, let's call it that, right? Some baby steps. Court said, well, we're not going to terminate her parental rights just yet.
I just have a question about like adoption and foster care. So let's say that, because one of the cases it was talking about because the kids were young, I think it was the case of Clinton, where the foster parents showed interest to adopt, but if they don't terminate their parental rights, then they can just be in foster care until they're basically old enough to get out without ever being adopted, because
Yes, that's entirely possible.
their parents still
Yep.
had their right, even though they lost custody for like all those 18 years, they wouldn't have the right to be adopted by someone else because the parents could still go back and get it reviewed.
Yep, yeah,
That's
yeah,
so sad.
yeah, if it
Every
never
6
goes that
months.
route.
Yeah.
Exactly, yeah.
Oh, that stresses me out.
Well,
And that was
this
the
little
reason
boy,
for
I
the
mean,
change.
It was 6 years here, this kid was in foster care for 6 years. How many more years are you gonna have him not really belong?
And that was the reason for the change in chapter 119 and 210, to allow juvenile court judges to hold the trials within 15 months and to make the determination if the evidence wasn't there to terminate parental rights. Okay, let's do the Jennifer
But
case.
is it standard approved the same, clear and convincing evidence?
It's still the
Both?
standard, yeah. Now Jennifer has dealt with an out-of-court statement as well. And it's a fairly old case, 1988. Ashley, want to do that one?
The father was accused of assaulting a female babysitter and both of his daughters. And
Not in the Jennifer case, but as part of the father's history, right?
Right.
Okay.
So the father is arguing that the drawings and the statements that his daughters made shouldn't have been allowed. The daughters had pointed out where the father had inappropriately touched them and other girls on Barbie dolls, and they drew diagrams. And the judge decided to let those into evidence, and they also let in hearsay, like out of court statements from I think a psychiatrist. And the father was arguing that those shouldn't have been allowed. And
What's the ruling of the appeals court on it?
They
The
said
appeals
that
court reviewed.
the court, they improperly.
Tell us first about the father's, you know, the guilty the criminal case, his guilty plea to the.
He
How was that guilty plea in an unrelated case used in this care and protection case regarding his daughter. So in other words, the department had that, when the department decided to file this custody case regarding this guy's daughters, the department also knew, right, that he had been found guilty of molesting the babysitter, right?
Right.
So how does the department use that in this care and protection case that has nothing to do with the babysitter but with his daughters?
They,
Is that okay
I
to
don't.
do that? And how does?
No, but I think, didn't they tried to use did they try to use evidence from that?
That's what I'm asking
Yeah.
you. In
And-
what way? In what way was the guilty plea evidence used in the care and protection trial?
But I'm not sure what exactly they used.
Somebody
We're
want
not-
It was shown to you that he could have then sexually assaulted his daughters.
So you abused the babysitter and he pled guilty, here's the here's the
Yeah,
guilty
here it is, you know,
conviction, so.
putting this into evidence.
Right.
There would
Obviously,
be
you abused his
objections,
daughters.
there would be objection from his attorney, right? And the department would then say, this is relevant. It's relevant to his fitness in this trial. His fitness is, it's not the end all and be all. If that's all you had, it wasn't gonna be enough. But you can, so you can use stuff from the criminal trial in the civil trial, and it's relevant to your fitness as a parent. Because the fitness issue in the care protection case is also about sexual abuse as well. What else? Because there's other rulings. What about the out-of-court statements of the daughters?
The,
So there was evidence
Yeah.
of teachers, social workers, you said psychologists, made by the daughters. Also, they also used the anatomically correct dolls, and in any event, they were all out-of-court statements, right?
Right.
So in what way is it appropriate for the judge to let this stuff come in?
when they're using it with other.
Yeah,
Evidence.
remember, come back to the definition of hearsay. You want me to say it again?
Be quiet. Any out-of-court statement offered to prove the truth of the matter asserted.
Yeah, offered in evidence to prove the truth of the matter asserted. So, these were out-of-court statements, generally inadmissible, all right? But they can come in if there's a hearsay exception, right?
Right.
So what's the hearsay exception that the appeals court ultimately rules on that would have been okay?
You mean 213?
No, that was, this
Oh,
is,
213.
this was way before
Oh.
the statute. Think of traditional hearsay exceptions. State of mind, state of mind.
Exception.
And the court says, the appeals court says, look, the judge could have let it in and said, I'm gonna let them come in on state of mind, but here's the judge's problem, he relied on them too much. He relied on them too much. He relied on them to prove the truth of the matter asserted. He or she wasn't careful enough to say, I'm letting them come in, but I'm only gonna use them for state of mind. So that was improper. The court improperly relied on these out-of-court statements that the children made. While a child's state of mind, now think of it this way, a child's state of mind, care and protection case is about a child. So you can always make that argument, well, Your Honor, they're adequate statements, but I'm just putting them in evidence to show the child's state of mind at the time. I'm not trying to prove through these statements that the child was actually abused, right? I'm just trying to show their state of mind. And then the judge says, well, okay, it's a hearsay exception. I'll let it in. But later on, when the judge makes the detailed findings of fact and rulings of law to prove by clear and convincing evidence that parent was unfit, it's not going to be enough if there isn't other evidence. That's the problem. We keep coming back to the abused and the abuser, and if there's nothing else, it's sad. It's sad. If there's nothing else, the department loses. The department loses. Oh, there was another thing, the fresh complaint doctrine, which is now called something else. Who's taking criminal law? Stop laughing.
Wait,
I might break up.
Are we supposed to remember that stuff?
Anyway, what's it say about fresh complaint? It's now called first complaint. Does this sound familiar? No, okay. Well, in a,
It says the judge
Go
did
ahead.
not receive any of the disputed evidence which we have discussed as fresh complaint, nor was it apparently offered as such. That was, I don't remember fresh complaint or first complaint.
okay. Child or adult gets raped, right? Gets raped. They go to someone, right? They go to a hospital, they talk to medical personnel, they go to the police, or child tells his or her mother, I've been hurt. He took off my blouse, he took off my pants, he did this, he did that, etc. That's the complaint, right? That person, whoever that person that the victim has talked to, gets on the stand at trial and starts to say, Martha said to me, immediately counsel on the other side, objection, out of court, say it again, out of court statement. You should rattle this off, Norman.
Well, I know, but I mean, the thing is that, you know, I had coin, I didn't have cash.
I want Colin's definition.
Any out-of-court statement offered
Offered in evidence to prove the truth of the matter. So the counsel would be saying,
Hearsay.
yeah, that this police officer can't be saying Martha said, right?
I'm telling Katie.
So as long as you
But
hear
stop.
Martha said, it's a hearsay.
Follow me with this. Initially, that's the objection, but then whether it's the department or the DA is then gonna say, well, Your Honor, I'm not really offering it for that purpose. I'm offering it on the basis of fresh complaint, or today it's first complaint, that this officer, or whoever this person is, was told by the victim after he or she was raped, and the victim will later take the stand to corroborate as well. So it's called evidence of fresh complaint or evidence of first complaint. Again, it can't be everything. If that's all you have, you've lost the case because it's not enough. It means that the victim's also going to be testifying as well. So that's the problem with the fresh complaint, first complaint issues in the child molestation cases, because for the most part, if you're the state, you don't want to have the child testify, trauma and everything associated with that. So the court says here, well, you know what, it didn't even come in that way. So the problems in the Jennifer case was, yeah, okay, you could bring his guilty plea in. I'll take that. You could even bring in all those out-of-court statements, and I could take that, but I could only take it for state of mind. And even if any of those even qualified as fresh complaint, and I could take that, it still doesn't rise to the level of clear and convincing evidence. And therefore, it's not enough. It's not enough. And that's what the Jennifer case stood for.
Was would they need the fresh complaint of the first complaint if it was a police officer or a hospital? Because if it was a hospital, because they bring it in as, you know, what's the one we bring it through with the medical, past record?
Medical,
But that's the problem. Again, no matter which way it comes in, you still have to have other independent evidence because of the level of proof that you need, clear and convincing evidence. Now, Mikkel is actually, I think, maybe the only one that I gave you that is not a sexual abuse case, but it's cited regarding the hearsay. Again, it's a hearsay statements sort of case.
It's such a difficult case. I can tell you about the facts, but since I didn't take any evidence or criminal, I'm not really.
Okay, start with the
But
facts.
the facts are, the family moved from France, and initially they had one child. They were billeted at YMCA, and that's when the first violent behavior was noticed by the father, who was shaking his 3-year-old son, and he put some violent behavior toward his wife and the child. And then the family left Massachusetts. 6 years later, they were back, and they already had 3 children at that time. In November '86, father was again violent toward his wife. He severely beaten her with a broom and was given an order to vacate the apartment. And for several months, the family lived separately, the father separate from the children and the mother. And DSS assisted the mother in the, then it was discovered that the kids were visited father and lived with him. And when DSS went to look at the condition they were living, they were dirty, there was no food there, the kids were unruly, they were throwing stuff everywhere, they were knives, children were running around, throwing things, including knives. Also, there was a history of father suffering from personality disorders. He was paranoid, narcissistic, antisocial. The mother displayed neither ability or a will to act independently. She was very dependent on her husband. When they evaluated children, Julia, who's a middle child, she was very depressed, didn't want to talk to anyone. Norman, who was the younger, he reflected some abnormal anxiety, and he had a problem with the speaking, and he was not talking for a year and a half. So the illness of the the illness and the conditions in the family made a conclusion for the child that rendered mother and father unfit as parents. But what the judge decided, in order to not to break the bonds in the family, he came up with the reunification plan. It was a 10-point service plan, which DSS was to design and pursue. And the parents appealed. One of the points they appealed, there was a testimony of the expert testimony, and they said that the expert used some lingo which was very technical and using some mythologies was only the licensed social worker should not possess. So it says that it was, this language was not, it was very technical, it was not, as a, expert testimony of a social worker. They also brought the, in complaint, and again, I don't know what it means, totem pole hearsay.
Where was the totem pole, totem pole hearsay contained?
It says it's,
Was it in the investigator's report?
again, in an investigator report, that they include statements made by third persons
Yep.
to individuals whom she interviewed in the course of her investigation. And that's what
Okay.
hearsay, as I understand.
So what was the bottom line? What was really wrong with this family?
I'm sorry.
I'll tell you what
Rolling
was
around my
wrong.
head for the
They
people
ate
online.
cake frosting. I call this the cake frosting case.
Ugh.
I love cake frosting.
Not for your meal.
Sometimes.
For your little treat.
So it's a custody case, not a termination case. Number one, what we heard from Jennifer before, the statements of the children, they're okay if they come in just for the state of mind. The last thing Alina mentioned, the investigator's report, hearsay's gonna come in. Totem pole hearsay's gonna come in as well. As long as, again, the investigator, they're on the stand, they can be cross-examined, they can identify, where they got this information from, they can identify their sources, et cetera. Again, it goes to, partly the general exceptions to not only the exceptions to hearsay rules, but also, because they're care and protection cases, because they're juvenile proceedings, and under section 21A, it's the rules of evidence, but both investigators, court-appointed investigators, and social workers become what's called qualified experts, and they can file things that have hearsay in them, and it's going to be allowed. That doesn't mean that you shouldn't dispute it in one way or another, and ask for redaction of things if they're not attributable sources or they're incorrect and whatnot. The other thing that's really important about this case is that unwillingness or inability, you mentioned the service plan, of the family to comply with the service plans of the department. That the department was, involved with this family for a long time, and this and that, and this and that, and the cake frosting, and the chaos, and chaos and degradation was used as what was going on in the home and so forth. So again, not a sexual abuse case, but the out-of-court statements are very important, and the hearsay of the investigator and the social worker that the court ends up later. Oh, and there's one more thing as well, too. The temporary removal, the removal of child from parents doesn't require, and this is really important, doesn't require that the child has suffered maltreatment. A judge sitting in this case, I'm quoting right from the doesn't have to wait for disaster to happen. In determining parental fitness, the judge may use past conduct to predict future ability. Keep that in mind when we're doing the sexual abuse case, and we've got little Jonathan, who wasn't molested by dad, but is included in the care and protection case. Okay, we're running out of time. Well, not running out yet, but I'm looking at the time and I want to get to these cases. So let's do Martha.
Yeah, I'll do that one.
Oh.
Well, this is a strange one because the mother dropped out of school when she was 17 and lived at home the whole time. It didn't work.
Mm-hmm.
And then she meets this guy when she was 33 and he was 47. So well, yeah, it's a good question, we don't know. But wasn't she tested later to have to be at the upper?
Okay, start first with, there's an out-of-court statements of the children's, I think it was the children's psychotherapist. children get on, I mean, not children get on the stand, psychotherapist takes the stand. And again, it's gonna be hearsay evidence, out-of-court statement, competent evidence, for the truth of the matter, asserted that, you know, the children told me this, and this is the psychotherapist, right?
Well, the judge admitted the testimony of the psychotherapist.
Yeah.
And that they had suffered at the hands of their parents, that the kids had made statements, and so it was. And then the judge also admitted.
Okay, so that was wrong though, right?
Yeah.
The judge shouldn't have done that,
Yeah.
but the SJC says that that was only, what?
That it was only.
You're just
Well-
repeating what I'm saying.
No. Well, I'm trying to give you the answer to that.
It was adequate statements of children.
They should be honored.
Psychotherapists should not have been allowed to testify because it was hearsay, didn't fall under any exceptions. However, it was not so bad.
Well, because it was only used to formulate the plan.
Harmless error, ring a bell?
Yeah.
Okay, let's move on to the next. What is the next ruling, or what are some of the other rulings of the SJC regarding this case?
Well, the mother objected because she wanted to be able to cross-examine the children.
Right, and so what does the SJC say about that point, about testimony of children in this case?
No, they're not down for that. They're.
Why? Why was it
because-
not necessary in this case?
Well, I think that there was sufficient,
More than sufficient.
more than sufficient evidence that.
Overwhelming independent evidence. So the SJ is saying they didn't need to do that, you didn't need to put them on the stand, even though mother's saying, yeah, I need my rights and so forth. There was what was the other evidence that was enough to yeah.
Other pictures?
Yeah, pictures, the parents' convictions on the criminal side, so like the Jennifer case, you have conviction, you have pictures depicting sexual abuse, so as the SJC says, there was overwhelming evidence, because there was overwhelming evidence, they didn't need to take the stand. And again, even though the psychotherapist erroneously testified, that was okay, we're gonna just call that harmless error, because there was so much other evidence that it amounted to clear and convincing evidence of unfitness. That's all you need to know about Martha. Now, Rebecca, we're finally at one of the other 233 cases. Rebecca is the case, a care and protection case, while the case after that, Quentin, is a termination case. So who wants to do Rebecca? I think we just have to do, was Rebecca and then Quentin is at the end of the readings for today?
Rebecca,
Tina.
Quentin, and Tina.
Oh, and Tina, okay. I'll be satisfied if we get through Rebecca and Quentin. Which is the old one that you were talking about, remember?
Oh, well, no, it was already that Martha, where the guy was 55
Oh,
when the last
okay.
child was born.
Oh.
And I don't know how a 55-year-old guy wants it 3 times a day.
Okay.
That's what it said.
Oh, everybody's taking a turn once, right? So who wants to do Rebecca?
Come on.
I'll ask questions instead. Let me ask questions instead. In a care and protection case, now, we read Colin, and that was the criminal case construing out the statutory PSA exception under 233A1, right? Now, in Rebecca, the court is looking instead at 233-83 in parent protection case. How are the safeguards different, relaxed, etc., in a case like Rebecca, as opposed to the criminal type of case that you saw in Collin? So again, I don't really care about the facts of Rebecca right now. I want to know that you understand how 233-83 would apply.
You don't have to show the child unavailable to testify. That one difference.
Say it not as a question.
You don't have to show that the child is actually unavailable to testify.
Why not?
Because of the detriment to the child concerning sexual abuse.
Keep going.
I should have just not looking at that.
When you looked at 233, 81, 82, 83, I don't know if you noticed that when you got to 83, it was much shorter than 81 and 82. Let me read 83 to you. Any out-of-court statement of a child under 10 describing any act of sexual conduct performed on or with the child, the circumstances under which it occurred or which identifies the perpetrator, offered in an action, under such and such and such, shall be admissible, and here are the provisos, provided, however, that the person to whom the statement was made, or who heard the child make the statement testifies, and the judge finds, so there still has to be a finding hearing, and the judge finds the statement is offered as evidence of the material fact and is more probative on the point for which it is offered than any other evidence which the proponent can procure through reasonable effort. Whole lot different from the, reliability, corroboration, all of the factors that we just discussed in Collin, right? Why?
Is that because in this case, it didn't really appear to be reliable testimony at all?
In what case? In Collin?
And Rebecca?
No, I want you to, I said before, that I don't really care about the facts of Rebecca. Rebecca is a test case just like Collin was, and it tested the statute, section 83. And so the question is, why are there less procedural safeguards in care and protection cases for allowing the hearsay statements, whereas in the criminal cases, and the civil is in the middle, in the criminal cases, there are many procedural safeguards. And you, Lily, or is it Ilana? Lily, you did the Collin, right?
Yeah.
Yeah, Lily outlined them well in terms of what the SJC said you gotta do. Norman, you were ready to answer it, I think.
Well, I thought I read that, that it was more lax just because the care and protection hearing was not, was not a criminal matter.
Absolutely. Keep going in that respect.
I just might have got to the end of my.
Because the due process is not needed?
Why is due process not needed?
Because it's not a criminal matter?
Okay, now let me play devil's advocate though.
Permanent
You guys
incarceration.
learned that parents have due process rights, right? Right?
Yeah.
So why not afford the parent in Rebecca or Rebecca-like cases the same protections that the defendants have in the Collin type of cases? Why not?
Because they're not gonna permanently be deprived of their, what was Collin, was it, of their children?
Yeah, they are.
It's not, for custody, it's temporary.
Yeah, but now you're likening Rebecca to Quentin, right? Quentin in section 82, right, deals with the termination cases, where they are going to be permanently deprived, therefore there are procedural safeguards. So it runs the gamut from, look at it this way, 81, criminal. Give me a criminal defendant's basic rights, Marina.
Due process?
Yeah, meaning what?
That's the.
What can happen to a criminal defendant? A defendant in a criminal case?
In jail.
Jail,
Yeah.
yeah, jail, for a long time, life, whatever, okay? Then 82, parents that are gonna lose parental rights. What are the rights involved there? You started to say it, didn't you? You said it before.
I did. They have fundamental rights for their children, you mean, or that they'll be deprived?
Permanently
Permanently.
and forever, right? And then Rebecca, section 83, just custody. So that's what I want you to walk away from with the statutory exceptions under 81, 82, 83. They're hearsay, it's a hearsay statutory exception, and it's only for child sexual abuse cases, and it's only for children under 10. And it can be held in a criminal case where there's lots of safeguards because of the defendant's absolute, due process, fundamental liberty rights. They can be held in civil and termination proceedings where parents are likely to lose their children forever, but those rights aren't as fundamental as the defendant's. So there's some prerequisites, there's some safeguards built in for the parents, but not as much as in the criminal. And then finally, with 83, it's just that little paragraph. Again, the proponent, the department has to show really very little, because you're not trying to get rid of the parental rights altogether. So keep those 3 statutes in mind, and you know what, we're running out of time. We have to assign the roles.
Do you know why they picked age 10 as the golden age? I mean, do they feel like children over the age of 10 would be able to articulate better?
Exactly, and should be able to testify, and even though it's traumatizing, they're not so young, and so forth. So here's the thing, okay. Elizabeth isn't here, and Kelly isn't here, but let's start with DCF attorneys. And there can be more than one. Do I add a volunteer?
I'll take one of the DCF attorneys.
You sure you don't want the district attorney?
I'll take either one.
That should be Elizabeth.
No, Elizabeth should get something different.
Oh, okay.
Yeah, Elizabeth?
Maybe she's a good district attorney.
I'm probably gonna assign Elizabeth to father's attorney. All right, Elizabeth gets to be Lee's attorney. She's gonna hate me for this. All right. DCF attorney. Danielle, you're a district attorney.
Okay.
If I don't hear volunteers,
I'll
I'm
be,
just doing. What, Norman?
I'll be at, is there a janitor's role?
Stop it. Norman, you're DCF.
All right.
Hey, we should play a name this time.
Court-appointed investigator, so I need somebody that's gonna really read the report, that, the report in the packet, and that person's gonna testify. Okay, Alina's gonna do that, thank you. Then I need a guardian ad litem. Your position is that the best interest of the children warrants protection from their father, that he's currently unfit, and termination may be the appropriate disposition. So now the guardian ad litem is in terms of ultimate positions. The court-appointed investigator, when you read the packet, Alina, you're gonna see that, you have reservations about abuse, but you're not taking the position that parental rights should be terminated, while the GAL is gonna take that position. So who wants to be the guardian ad litem? Okay, I'll give that to Kelly if nobody wants it, because she's not here. Kelly? All right. Kelly, you're the GAL. All right. Now, I need an attorney for Alicia, the oldest daughter. Ashley? Okay. I need an attorney for Jason. Arena? Need an attorney for Jonathan. Alana? Don't worry, Lily, I'm gonna give you something. Wait a minute, 1, 2, 3. Elizabeth's doing that. 1, 2, 3, 4, 5, 6, 7, 8. Okay, Lily's gonna be my clerk. Is that all right?
Yeah, that'd be
Okay.
nice.
Because you're gonna, afterwards, you'll be taking notes,
Okay.
and at the conclusion, will, help you determine what I should be doing with this case. So notice that it says, the case has been scheduled for trial, the judge has ordered, mediation. Actually, okay, wait a minute, I'm not a judge, all right? So you're gonna help me mediate instead, okay? All attorneys involved must be prepared to summarize their position in this case, using the facts, the case law, statutory law. So this is gonna be, and notice that it's only attorneys, again, not the judge, not any of the children, not any of the parties. So it's only attorneys and, of course, the investigator and GAL. So read through the rest of the cases, and that's what we're gonna be doing, on Tuesday.
My role is the criminal aspect.
Yes, you're the
Right.
district attorney.
Criminal.
Yep, yep.
So, when you say that, we're reading through,
You're reading through all of the cases as well as this packet.
Do you have an extra packet?
I do. Come get one.
that's all so that's Amaral, all the rest of those?
Yes.
Okay.
Yeah. Okay, so I'll see you on Tuesday.